What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly case update. I hope everybody is having a terrific Tuesday. I just came back from the DMV. I had to renew my driver's license, and oh my gosh, if you haven't done that already, please do so as soon as you can and get it over with, because you have to get an appointment way in advance, and it's crazy. So I got 3 cases for you this week. They're all very interesting, and they all kind of have to do with paternity. So the first one is Martinez versus Cuevas. This is out of the 5th DCA. This has to do with disestablishing paternity. So interesting case factually here. It's a divorce case actually, but the father had a vasectomy. There's 3 children involved. After I think it was the second child, the father had a vasectomy, right? And so then now when the parties are getting divorced, he goes ahead and has all 3 of the children undergo a DNA test, and he finds out that 2 of the kids are not his. Kids numbers 1 and 3, let's say, the youngest and the oldest are not his. I don't know about the middle child. So before his wife had the youngest child, he had a vasectomy. So the wife comes in and says, wait a minute, you can't disestablish paternity because you knew that you had a vasectomy. So basically you knew that this kid was probably not yours, I guess, as to the youngest child. And so therefore you can't show newly discovered evidence sufficient to get a disestablishment of paternity. So that's how it goes. If you're trying to disestablish paternity, you have to file an affidavit showing newly discovered evidence, file test results showing that the child is not yours, basically DNA test, and then file an affidavit saying you're current on child support. So the wife was trying to say, look, you knew you had a vasectomy, you knew that there was a likelihood that this child wasn't yours. So therefore you can't satisfy the newly discovered evidence prong. The trial court apparently agreed with this, but apparently the mother and the wife told the husband that she thought that this child, the youngest child, was his, even because vasectomies are not 100%, and sometimes if you have sex too early before the vasectomy is basically effective, within I think the first 3 months or something like that, the child could still be yours. So, and logically, the youngest child, it has nothing to do with the vasectomy. So of course that would be newly discovered evidence. So that got reversed. So the father was able to disestablish paternity, or at least make his case in order to do so, regardless of whether he had, regardless of whether the newly discovered evidence was only the paternity test results. The case law is actually split. The DCAs are split on whether new test results by themselves are sufficient to establish newly discovered evidence. Regardless, he's able to move forward with his disestablishment of paternity. Next case is Department of Revenue on behalf of Brown versus Gardner, another paternity case. Now this one is kind of a little different. So in this one, there's a father. This looks like a DOR case, and the father was trying to get DNA test results. He filed a motion for paternity testing in this DOR case. Now the problem for him is that he already signed that voluntary acknowledgement of paternity, which usually happens in the hospitals. I don't know how it happened here, but he signed a voluntary acknowledgement of paternity, and 60 days goes by and he doesn't rescind it. So therefore he is the legal father of the child, right? Paternity is established. So for him, in order to get a DNA test, he would have to put something in controversy. There would have to be something in the pleadings that would allow him to get a DNA test. He has to show good cause, and he has to show the in controversy aspect in order to get a DNA test. So here he couldn't, because he didn't have any pleading to disestablish paternity, and he didn't have any pleading showing that his acknowledgement of paternity was the result of duress, coercion, or material mistake of fact. So those are the only ways that you can disestablish paternity, essentially. You can file that, what the other gentleman did in the other case. You can file to disestablish paternity, but that's like an actual petition to disestablish paternity, or you can file a motion to set aside your acknowledgement based on duress, coercion, or material mistake of fact. This gentleman didn't do any of those, so therefore the trial court erred in allowing a DNA test to go forward. So the petition for writ of cert was granted. You can't get a DNA test unless you put that in controversy, put the paternity in controversy in those two ways. The last case for today is Oramas versus Asencio. This is a discovery case. So basically, it's a mom and a mom and dad. Basically, they have an autistic child. They each was trying to claim parental responsibility. So each filed competing petitions and counter petitions. The mom was trying to get sole parental responsibility. The dad was trying to get an order establishing shared parental responsibility over their autistic child. The autistic child was being cared for by the aunt, by the maternal aunt. And so the father is trying to depose the maternal aunt and files a subpoena ducis tecum, serves a subpoena ducis tecum on the non-party aunt, asking for, I guess, all sorts of documents, all calendars and all kinds of information, including financial information. That's the issue here. The thing was, his child support was not at issue. There were no financial issues at issue in this case. It solely had to do with whether the parents were going to have sole parental responsibility over the child or shared parental responsibility. So the finances of the aunt were not relevant. So he was not able to get bank statements, tax returns, things like that. He was trying to do this because I'm sure in his child support calculation, they probably included a line item for daycare or child care, right, in the child support. And so the father, I think, was saying, "Oh, the mom is not really paying that child support to the aunt, to her own aunt." And so, but the trial court, the appellate court said, "Well, that doesn't matter really. It's irrelevant. There are no child support issues in this case. It's only shared parental responsibility or parental responsibility. So you're not allowed to get the financial records of a non-party. That's a high burden in order to get the financial records of a non-party, an individual." Florida has a right to privacy in their constitution. And so it's very difficult to get that. So that petition for writ of cert was granted. The paternal aunt's protective order should have been granted. All right, guys, that's it for today. I hope everybody has a wonderful week. I will see you guys next time.